Be ready? Start. 1 month and therefore the term of the committee, even if assumed to be a valid committee, stood expired in the month of November 2013. Therefore, elections held in the month of March 2014 by the outgoing committee, which had become defunct, were completely invalid in as much as elections could have been held only by a Prabandh Sanchalak stop. Shri Pathak further submitted that from the records it is clearly established that the Prabandh Sanchalak was managing the affairs of the institution on the date on which the elections were held. Therefore, such elections could not have been held by the outgoing committee stop Stencha. At this stage, it would be useful to observe that under the scheme of administration, the term of the Committee of Management is 5 years with a grace period of 1 month stop. Clause 10 within bracket A of the scheme of administration provides that on expiry of 5 years, the officer bearers of the outgoing committee would continue for further period of 1 month, and if within the said period fresh elections are not held, then the committee of management would become defunct and the regional joint director of education would appoint a Prabandh Sanchalak for managing the affairs of the institution and to hold the elections stop. Shri G.K. Singh, appearing for the petitioners, submitted that even though the election of the last outgoing committee was held on 12/10/2008, but since the committee was accorded recognition on 31/3/2009, the term of the committee would commence from that date and therefore the term would extend up to April 2014 stop Stencha. Shri P.N. Saxena, learned counsel for the appellants, contends that the procedure adopted by the two professors in declaring the result on a manual check of the OMR sheets is in contravention of the mode prescribed, which should have been done by the computer center through a scanner stop. He submits that there was no occasion for the two in charge professors to have undertaken the evaluation themselves manually stop. He further submits not only this, the manner in which there has been a substantial change in marks of one of the students and few minor changes in the case of 6 other students raises a serious suspicion and a genuine doubt about the conduct of the two professors who undertook the exercise of change of answer sheets manually stop. He further submits that there was no provision for any such rechecking or scrutiny and the declaration of the list on 1/4/2010 was unspotted by any authority stop. It has further contended that the learned single judge committed an error by accepting the submissions made by the respondents, which was directly in conflict with the relief claimed by them stop. He submits that the respondents had clearly questioned the correctness of the subsequent list and had prayed for admissions being made on the basis of the first list published on 19/2/2010 stop. Accordingly, it is submitted that the learned single judge ought not to have granted the relief as prayed for stop. Shri Saxena has further invited our attention to the application moved in this special appeal, making a prayer that an appropriate direction be issued to the university to ensure transparency in holding of the examinations and the declaration of the results as well as evaluation of the OMR sheets, so that in case any student has any doubt, the same can be ascertained by adopting a fair procedure stop Stencha. Shri V.K. Singh, learned senior counsel for the university, contends that the university may not have filed an appeal against the impugned order, yet the university supports the cause of the appellants and at the same time would abide by the orders of this court stop. He, however, takes exception to the finding and observations that were made by the learned single judge on the steps taken by the Vice Chancellor, and he submits that the Vice Chancellor, in order to ensure fairness, had taken a decision to cancel the examinations on the asking of the candidates themselves stop. He further submits that prompt decision by the Vice Chancellor was taken as he was wholly unaware about the two in charge professors having manually evaluated the results, who upturned the same through a revised list stop. He further informs the court that the Vice Chancellor was not made aware of any such action being taken by the two professors, and they did it on their own without any authority stop. Accordingly, the Vice Chancellor immediately constituted an inquiry committee, and after having received the findings of the said committee, cancelled the examination in order to ensure fair admission in the postgraduate courses stop stanza. Shri Ashok Khare, learned senior counsel for the respondents, had come with a case that as a matter of fact there was an error of tabulation, and even though the respondents petitioners had initially prayed for maintaining the selection on the basis of the first list, yet they were satisfied with the second list, and therefore this court may not interfere with the directions of the learned single judge, more so when the admissions have already been completed within the time schedule given by the apex court stop. Having carefully examined the record, we may at the very outset clarify that in view of the specific schedule fixed by the apex court for finalizing of admissions for the allotted courses by 30/6/2010, we would not prefer to disturb the admissions and issue directions for holding of a fresh examination stop. In our opinion, this would violate the deadline fixed by the apex court in writ petition within bracket civil number 189 of 2010, Naval Asija and others versus Union of India and others, disposed on 13/5/2010 stop. The admissions as intimated by the learned counsel having been completed, the same need not be disturbed at this stage stop stanza. It is submitted that the petitioner filed a review petition which was rejected by learned single judge, against which the petitioner has filed a special appeal defective number 402 of 2013, which is still pending stop. He submits that in view of the aforesaid, the order of punishment has become final, which includes the recovery of the amount and which is short to be recovered by a procedure provided in the rules, which is retrospective in nature stop. The procedure and the method of covering the amount does not give any substantive right to the petitioner on the basis of which he may challenge the recovery proceeding stop. Shri Shrikant Shukla further submits that in pursuance to a public interest litigation filed in Lucknow bench of this court, an inquiry was made with regard to serious irregularities in shortage and distribution of food grains, in which an investigation was conducted by the special investigation team of the state government and in which these godowns were also involved stop. Large-scale irregularities have been found in the investigation stop. Large quantities of food grains were found to be transported through trucks, whereas the registration number of the vehicles were found to be of scooters and motorcycles stop. He submits that the court should not interfere and relegate the petitioner to file an appeal, and that since the petitioner has not submitted adequate security in compliance with the orders passed in writ petition number 57919 of 2011, the writ petitions be dismissed stop stanza. We have considered the arguments stop over.